Hello viewers, in this lecture we are going to discuss another important constitutional functionary of the Union Executive, that is the Prime Minister and his Council of Ministers. Let me share with you in the beginning that we are a parliamentary democracy, and in parliamentary democracy, which is based on the British model, the real executive power lies with the elected government, that is the Prime Minister and his Council of Ministers, his team of ministers. Sir Ivor Jennings has very rightly commented in his treatise on the Constitution that the position of Indian Prime Minister is more similar to the Prime Minister of the Britain than the President of USA, because in USA there is a presidential form of government and President is the real executive head. There is no position like Prime Minister. But in UK, the Prime Minister and his team are the real executive head, though they have a monarchy. They have a formal executive head as Queen. We have the formal executive head as a President because we are a republic. Britain still is a monarchy because the executive head of the state is Queen, is monarch. But the real powers lies with the Prime Minister and his team. So the Queen acts on the aid and advice of the Prime Minister. Back home, we are more closer to the British pattern because we were ruled by the British government for more than 200 years and we were very much familiar with the parliamentary form of setup. There were several occasions, particularly when emergency was imposed in 75 to 77, that should we adopt the American model of the presidential form of government where the president is directly elected, or we should retain the parliamentary form of government. But at the end of the discussion, we agreed that we will continue with the parliamentary form of government, which means that the elected government is responsible to the parliament. Whatever they act, whatever laws they pass, whatever administrative powers they exercise, they are accountable to the parliament. And President as an executive head of the state will monitor, will act on the aid and advice of the Council of Ministers. Having said this point, let me come to the constitutional provisions. Article 74 says that there shall be a Council of Ministers headed by the Prime Minister who shall aid and advise the President in discharge of his executive powers. Because we have already said, Article 53 says all executive powers are discharged by the President, either himself or through his aides. So this aides or this team is the Council of Ministers. We have to read Article 53 in conjunction with Article 74, which says that the President shall act on the aid and advice of the Council of Ministers, which is headed by the Prime Minister. And what advice has been tendered to the President cannot be called in question in any case. Now, this particular provision, which was not agreed by the Supreme Court in S.R. Bommai's case. The Supreme Court in a famous S.R. Bommai case that is known as Assembly Dissolution case and State of Rajasthan versus Union of India, when series of assemblies were dissolved, President rule was imposed, the Supreme Court said that we do not agree to this view that what advice was tendered by the Council of Ministers to the President cannot be called in court, cannot be examined or cannot be questioned by the court. that we do not agree. If there is a malafide, if there is a guilty intention, we will examine. Our power of judicial review will go to that extent, and we can quash the decision taken by the President, the order of President rule which has been issued on the aid and advice of the Council of Ministers. We can ask, we can examine it. Second thing is, in 42nd Amendment, again that was passed during the emergency era, an amendment was made that President shall be bound by the aid and advice given by the Council of Ministers. The word shall was used in place of may, and as a student of law we know the interpretation that when there is a shall, it means the President is bound by the aid and advice of the Council of Ministers. He cannot go beyond that. Whatever advice has been tendered by the Council of Ministers, President has to accept it on ditto lines. This provision, word shall, was turned down by the Supreme Court, and now the President has, in 44th Amendment, this word was removed, and court also said that this President is not always bound on the same line. He cannot be always made liable to accept the recommendations or aid and advice of the Council of Ministers on dotted lines. Therefore, there is another provision by 44th Amendment Act. It was added that President can send for reconsideration the aid and advice tendered by the Council of Ministers. Suppose the Council of Ministers has advised the President to impose the President rule. The President can ask the Council of Ministers to reconsider this advice. But again there is a rider. After reconsideration, if the Council of Ministers reiterates that yes, we again send to you this advice, we have reconsidered your suggestion, we reject your suggestions, and we are sending you this resolution or this advice once again, President has to sign it. That is why the constitutional expert says that President is a titular head, he is a nominal head, he has a limited choice of sending the advice tendered by the Council of Ministers just for a reconsideration. He cannot disagree with the advice, he cannot reject the advice, he has to accept it. This is what the constitutional provision laid down in Article 74 states. Now that comes to the next point, that what are the limited discretionary power of the President. The Prime Minister is appointed by the President. Then we come to Article 75. We have to read all these articles together to understand the real nature of the power. There shall be a Council of Ministers headed by Prime Minister, who shall aid and advise the President. Aid and advice given by the President is Council of Ministers is binding on the President. However, he can send it for reconsideration. This is what Article 74 says. Article 75 says that Prime Minister shall be appointed by the President. Here lies the catchword. We have seen there have been situations when no political party was commanding the majority in Lok Sabha, in House of People. And as per the parliamentary form of government, President should appoint. President is bound to appoint a person who commands the majority, whose party commands the majority in the Lok Sabha after election, and that person has been elected as leader of that political party, which commands majority in the House. In that situation, President has no problem, he has no choice. But when there is a fluid situation, when no party has a majority in the Lok Sabha, there is a mixture of several political parties coming together to form a platform or an alliance, then in that situation, to whom the President will invite to form the government, to whom the President will appoint the Prime Minister is a crucial issue. And we have seen during post-emergency rule, there was a Janata Party government that fell down. Then the late Chandrasekhar and Sri Deve Gowda, they were made Prime Minister. They were not commanding respect or majority of the House. But President invited them, exercising his discretionary power. I would say, as a student of constitutional law, that this is the one area, particularly in those grey situations when no political party enjoy majority support in Lok Sabha, President by his wisdom will appoint a person as the Prime Minister to head the government. Once the Prime Minister is appointed, then there is no problem, because the other ministers are appointed by the President on the advice of the Prime Minister. So once the Prime Minister has been appointed, he will advise that these persons should be appointed as a ministers, and the President will administer them oath of office. But in the matter of appointment of Prime Minister, the President can exercise a great amount of wisdom and discretion in those situations when one particular political party is short of majority in the Lok Sabha. One interesting point we have to understand is that after appointment of the Prime Minister, on the recommendation of the Prime Minister, the President will appoint the ministers for the Union, and it is the prerogative of the Prime Minister. The parliamentary democracy clearly says it is a convention. Who will be appointed as a minister? Any person can be appointed as a minister, but there is a constitutional limitation. Within his appointment as minister, within 6 months, he has to become member of either of the house, that is, either he should be elected to the Lok Sabha or he should be elected to the Rajya Sabha. If within 6 months of his appointment he fails to get elected in the Lok Sabha or Rajya Sabha, either of the house, his ministership, his tenure will terminate. So that is a condition, because parliamentary form of government, the Council of Ministers is accountable to the Parliament. So a person who is appointed as a minister has to be a member of either house of the Parliament within 6 months of his appointment. Now the government sometimes appoint very eminent or competent persons. They are not member of the Parliament, but within 6 months the government will get them elected either through Rajya Sabha or in the Lok Sabha. Our former Prime Minister Shri Manmohan Singh ji was not member of the Lok Sabha. He was member of the Rajya Sabha. That is permissible. Generally, the convention says that the Prime Minister should be an elected person of the Lok Sabha, but that is not a written law. So he should be a member of the either house. So if a person is elected within 6 months of his appointment to either of the house, he can continue as a minister. But if he fails to get elected, then his office will cease. Now, it is the prerogative of the Prime Minister. Prime Minister plays very important role in the governance of the country. In fact, he is the real boss. He is a real, in the constitutional term, he is a real executive head, because he has the power to recommend the appointment. President will appoint the ministers, but only on his recommendations, and ministers will be removed only on the recommendations of the Prime Minister. The President will not remove ministers or appoint ministers without the recommendations of the Prime Minister. Of course, the President will appoint the Prime Minister and remove the Prime Minister on his own account based on certain constitutional conventions which I have just mentioned. Therefore, we have to understand what is correlation, what is constitutional position of Prime Minister vis-a-vis President. Because in parliamentary democracy, we have to understand that what is the legal and constitutional position of Prime Minister within his cabinet, and what is the constitutional relationship of Prime Minister with the President, who is the executive head of the state, and Prime Minister is the real political head of the government. As I have said, that Council of Ministers will be appointed by the President on recommendations of the Prime Minister. In Article 75, an amendment was made in 2003. What actually happened, that there was no limitation for number of ministers to be appointed. Of course, Prime Minister will be one person, but how many persons will be appointed as cabinet ministers or in the Council of Ministers, there was no provision. Say for example, just an hypothetical example to understand the situation, there are 545 members of the Lok Sabha. 2 are nominated and 543 are elected. Can the President, on the advice of the Prime Minister, appoint 200 ministers, 200 members as ministers, 300 members as ministers? Can all the members of the Parliament, say for example 500 members, can be appointed as ministers? That would be a great burden on the exchequer of the government. And we found that there were jumbo-sized cabinets, not only in the center but also in the states. Therefore, to check that situation, the Constitution was amended in 2003, and the number of ministers was fixed constitutionally. It cannot exceed 15% of the total elected members of the House of People, not House of the Council of State. Say for example, there are 543 elected members of the House. So 15% of that, nearly 81 or 82 persons, leave aside the fraction, they can be appointed. Upper limit, you can say the 82 can be appointed as the ministers. That is to check the government expenses, to make the Council of Ministers a very limited body and efficient body. So that is an important constitutional amendment which was made in the Constitution to limit the jumbo size or oversized Council of Ministers. Now this Council of Ministers is responsible to the Parliament. Whatever action they take, whatever decision they take in their respective ministry, first of all, there is a principle of collective responsibility. All major decisions of the government are approved by the Cabinet. Cabinet is a body of ministers headed by Prime Minister, where the different ministries, different departments, head of the departments as ministers, they will put forward certain schemes, laws which are to be passed by Parliament, the schemes which are to be launched, or the major decisions which are to be taken, they will be approved by the Cabinet. And as per the rules of the conduct of the government, business of the government, periodically, maybe once in a fortnight or as and when required, the Cabinet meetings take place. Prime Minister chairs the Cabinet meeting, or in the absence of Prime Minister, the senior most minister will chair the Cabinet meeting, and all major decisions will be taken by the Cabinet. And then wherever the approval of President is required, those decisions will be sent to the President as an aid and advice, and President will approve those decisions. This is how the government at the executive level at the Union works. And whatever laws have to be passed or whatever laws have to be amended according to the need of the society, their draft will be first approved by the Cabinet. Then the government, the respective ministry, will move a bill in the Parliament for making it a law. That we will discuss separately when we discuss Parliament and legislative procedures. One more important point, as I mentioned, the relationship between the Prime Minister and the President. Article 78 imposes a duty on the Prime Minister. Prime Minister is appointed by the President. He works on behalf of the President through his cabinet. It is the duty of the Prime Minister to inform the President, to communicate the President about the decisions which are taken by the government. So, a harmonious relationship between the Prime Minister and the President. Prime Minister, as Ivor Jennings has rightly called, is first among the equal. It is the Council of Ministers that works. Prime Minister as his head is first among the equals. All ministers are equal. He is first among the equal. And he is a bridge. He is a link between the government, actual government, and the constitutional head, that is the President. So, a good Prime Minister, a good relationship will work when Prime Minister periodically visits the President, apprise him of the conduct of the government, of the various decisions which are taken. Whenever the Prime Minister goes abroad for international visits and agreements, as a matter of courtesy, the Prime Minister, after coming to the country back, would visit the President and apprise the President what decisions, what agreements, what talks have taken place between India and the country where the Prime Minister has visited. That is necessary to establish a harmonious relation between the President and the Prime Minister. According to the scheme of the Constitution, the Prime Minister shall chair the meeting of the Cabinet. All decisions, resolutions passed by the Cabinet shall be sent to the President for his signature, and it is at this juncture the role of Prime Minister as head of the Cabinet assumes great significance. According to Ivor Jennings, the Prime Minister is first among equal. All the members of the Cabinet are equal in their position, but Prime Minister is first among the equal. He heads the Cabinet and he is a link between the Cabinet and the President. Therefore, the office of Prime Minister has a great responsibility. Article 78 of the Constitution casts an obligation on the Prime Minister to keep the President of India informed from time to time about the various policies framed by the government, important decisions which are being taken by the government through the route of the Cabinet, and particularly when some policy decisions are taken, the President has to be taken into the confidence, because ultimately the matter, the law will go to the President for his signature, for his approval. Therefore, a harmonious relationship between the government, which enjoys the real political power, and the President, which is a constitutional head, is very vital and very critical for the efficient and trouble-free governance of India. So, according to Article 78, the Prime Minister shall periodically inform to the President of India the various decisions as I have mentioned. President has also the power to call upon the ministers or the Prime Minister and explain or seek information and clarifications on the issues of the governance. So, this article makes the President effective in the sense that he can also call the Prime Minister and seek the information, or he can call the ministers and seek the information about the conduct of the government. And the Prime Minister has a duty to visit President periodically and inform him, keeping him in confidence about the functioning of the government. Here, a working and a good relationship, harmonious relationship will be very important. If we go back and see the political situations, we find that there have been instances when President was ignored. The government was not having cordial relationship with the President, I may cite the example during Congress rule when late Rajiv Gandhi was the Prime Minister and late Gyani Jail Singh Ji was the President. Situation arose when there was a lack of mutual confidence, lack of mutual respect. And in such situations, the political crisis may come, political crisis may erupt. Whereas recently, as a student of constitutional law and having the understanding of political science and political relationship, we can say that during last tenure of the President Sri Pranab Mukherjee and the beginning tenure of the present Prime Minister Sri Narendra Modi ji, their chemistry, their relationship was very good and they had a smooth sailing. Therefore, coming back to the Constitution, we can conclude by saying that the executive power of the Union, of the central government, formally vests in the President of India, and in the absence of President, the Vice President will work as the President. But the real power, real political power lies with the Council of Ministers headed by the Prime Minister, because we are a parliamentary democracy and the Council of Ministers is accountable to the Parliament. Therefore, the working of and the relationship of President and Prime Minister and his Council of Ministers is very important for the successful governance of the country.